Hi, my name is Robert Chelle with Chelle Law, and my firm assists physicians with employment contract issues. One thing I want to talk about today is what are the remedies for breach of a physician contract? So we'll kind of break it down into simple terms. First, what is a breach of contract? Well, the entire point of an employment contract is to delineate the terms of what are the responsibilities of both parties, how long the contract lasts, how it's terminated, how they get paid, what are the restrictive covenants. So there are plenty of things that both sides have to provide to the other. And so if in the contract one of the parties is not following through, then how is that fixed in this case? I'm saying, how is it remedied? So let's talk about termination of any kind of physician contract. Well, one, you can obviously terminate the contract for cause. So meaning if there's a breach of contract, either party can usually terminate it with a certain amount of notice, and we'll kind of get into the details of that. Or there's also without cause termination, meaning either party can terminate the agreement with a certain amount of notice to the other and for any reason. So usually it's 60 to 90 days in most physician contracts. So let's just say a physician is unhappy at a job. All they have to do without cause termination is just give the employer notice. Hey, giving you 60 days notice, plan your leave. This gives you enough time to kind of, work on continuity of care, moving my patients to someone else, maybe hiring another provider. That's one way of terminating the agreement. Now, for cause, as I said before, is if there's a breach of contract. So in any contract, there's also going to be a long list of things that the employer can fire the physician for. So, and these are things that can and can't be remedied. So kind of the obvious things, if the physician loses their medical license, DEA registration, maybe they're uninsurable due to a number of malpractice settlements, they can't get licensed or credentialed with any of the insurance companies, they're excluded from Medicare, Medicaid with CMS due to being put on the Office of Inspector General exclusionary list. So those are things that happen that for the most part can't be remedied, or at least not remedied quickly. So that would give the employer justification to fire the physician immediately. Now, things that can be fixed, usually there's also language about maybe the physician needs to follow policies and procedures of the employer. There's some kind of code of conduct where they have to get along with the other employees of the practice or the hospital. And so in a case where one party thinks the other party's in breach, but it can be fixed, that's called a cure period. And there should be language in every contract that talks about how any kind of breach can be cured. And so what that means is, and for the most part, it's usually 15 to 30 days. And so let's just say a physician isn't being paid on time, or they're not being paid the bonus that was actually in the contract. The physician can give the employer a written notice and say, look, this is what the contract states. You're not following through. You're not paying me on time, or you're not paying me enough, or whatever the problem is. You are in breach of contract. And let's just say it's a 15-day cure period. You have 15 days to cure this breach. If not, I have the opportunity to terminate the contract immediately. So on the employer side, if it's true, if they're not paying in time or they're not calculating it correctly, the way that they can remedy the breach is to fix whatever the problem is, pay the physician what they're owed. And in that case, they have remedied the breach. The physician can no longer terminate the contract for cause because whatever the problem was is fixed. And then once again, the only way they can then terminate the contract is without cause. using the example before of, let's say, a physician isn't following some kind of policy, the employer can then give the physician notice. I don't know, maybe it's excessive tardiness, or in the contract it states that the physician will work one weekend a month and they're refusing to work, on the weekend or something like that. Then same thing would happen. The employer would send the physician notice, they're in breach of contract. The physician would then have a period of time to fix the breach. And let's just say the weekend example, they start working on the weekends, and then the employer can't fire them for cause anymore. They'd have to terminate the contract without cause. It's pretty rare, honestly, for it get to the point where one side would give the other side notice that they're in breach of contract. And if it is, it does happen. 95% of the time, it's due to some kind of payment issue. At least on the physician side, they're not being paid in time. They're not being paid the correct bonus. And then usually on the other side, if it's a breach can be remedied by the employer, it's usually some kind of behavioral issue with the physician, or some kind of productivity issue, meaning they're, the physician is refusing to see kind of the expected amount of patients. They're not doing, seeing the encounters. They're refusing to speed up, in a safe manner. I'd say that's kind of the normal reasons why an employer would decide to terminate a contract for cause. And those are things that can easily be remedied by a physician as well. They just, fix whatever the issue is as well. If there is some kind of dispute over if someone is or is not in breach of contract, there will also be language in the contract that usually will state how a dispute is resolved. More and more arbitration clauses are kind of the standard. And so if there was some kind of dispute that just couldn't be worked out, the parties would be required to go to arbitration. Arbitration is where an attorney, usually a retired judge, something like that, would then hear both sides of a case. There's limited discovery. And then both sides would kind of plead their case to the judge or attorney. And then that person would render a binding decision. Benefits of arbitration, it's generally cheaper and faster than litigation. Litigation is where you would sue someone in court. Now, if there was no arbitration clause in the contract, then that's what would happen. There usually would be some kind of venue provision, meaning if there is some kind of dispute, this is where the lawsuit has to start. It usually is in the county where the physician is working, and then you would have to hire an attorney who would then file a lawsuit against the employer to enforce whatever the issue was. So anyway, hopefully that was helpful. That was kind of how to remedy a breach of contract. If you have any questions, you can always call my law firm at the phone number listed below in the description, or you can reach us at our website, ChelleLaw.com. That's CHELLE law.com. And appreciate you watching the video. Thanks.